So should you go to trial so that you can get more money out of your workers' comp case because you want to tell the judge how injured you are or how the employer treated you improperly or the insurance company denied treatment? So I talked to a lot of injured workers. They want to go to trial because they believe the judge can give them more money than they would get if they settled, because then they can tell their story. But I will say that's not usually how it works. What you see a lot of the time on television and even in superior court with motor vehicle accidents, that type of thing, there will be a dispute over the amount of recovery that the injured worker, I should say the plaintiff, should get. So what you see on TV, there's experts on both sides arguing the diminished earning capacity, pain and suffering, loss of consortium, that type of thing. But that just doesn't come into play in workers' compensation. So what a judge will do in workers' compensation, a judge will issue a decision over a dispute. But if the dispute is, I want more money out of my workers' comp case, that's not generally something that the judge can address. So let's kind of take a step back and go through it. Disputes that will go to a judge, trials that will take place in workers' comp, if there's a psychiatric injury, stress, anxiety, depression, and that's denied on a good faith personnel, lawful, non-discriminatory personnel action by the defense, that will go to trial, or at least it could, because the applicant's side wants a psychiatric claim, the stress or anxiety, and the defense is denying it completely. So that's something that could go to trial to decide whether or not there was an industrial injury. Likewise, let's say nobody saw you fall down at work and get hurt, and the employer has records that show that you got hurt before you came to work. That's something that may go to trial to determine whether or not the injured worker is more believable or the employer's witnesses. But that's not going to be a dispute where the judge is going to decide how much money to award. You see, what a judge has to do in workers' comp, they can award temporary disability, they can award medical treatment, they can award permanent partial or permanent total disability. But the permanent disability that a judge awards has to be based on a medical report. So for a lot of injuries, if it's an accepted claim, the insurance company's been paying benefits, the QME found the injured worker, found you permanent and stationary, and that report rates out to, let's say, 15% permanent disability, whatever that is, let's say $17,000. If you settle with stipulations with request for award, you're going to get the $17,000. If you go to trial and explain to the judge how injured you are, how the insurance company didn't treat you right, what the judge is likely going to award is 15% permanent disability, the same $17,000. The judge isn't going to award more money based on your testimony unless it's a very rare circumstance, or conceivably the judge could find that the doctor's report is not substantial medical evidence and then throw that medical reporting out, and you would have to get a new QME, or the judge could order an IME. But again, it's not a situation where the judge is going to say, I tell you what, injured worker, this report rates out to $17,000, but I think you should get $20,000, or I think you can get $25,000. That's just not the way the system works. Similarly, with regards to a settlement with a compromise and release, let's say the report rates out to 15% permanent disability. Let's say that's $17,000, just hypothetically. And you're trying to settle everything out. You want $20,000 from the insurance company, but they only want to pay $10,000 for that closure value, the future medical. The judge can't issue an order on that. So you can settle if you and the insurance company can come to a meeting of the minds. But if you take that case to trial, again, the judge is only going to be able to order or award the permanent disability of 15%. And so there's really no dispute. And the judge can't order the insurance company to pay more for future medical closure value for a compromise and release. So 9 times out of 10, the bottom line is when I talk to people and they say, I want to go to trial, I want the judge to hear this because I'm going to get more money. It's just not how the workers' compensation system works. The judge can award permanent disability. He can find, or she can find, that the report of the QME is substantial evidence or isn't. They can find in accordance with that. But the judge has to rule based on the medical evidence that is presented to him or her. And in rare circumstances, there might be a dispute between some vocational experts, but really the judge has to rely on that medical reporting. And if the medical reporting says 15% permanent disability, it's going to be 15% permanent disability. So most of the time, going to a judge is not going to end up getting you more money unless there's a more foundational dispute. Is the reporting substantial evidence? Was there an industrial injury? That type of thing. If you have questions on this video, drop a comment down below, see if we can answer that. And if you found the video helpful, hit the like button.